Gives me great pleasure to welcome Associate Professor Alison Silling from the University of Technology, Sydney, to give us a talk on viewing liens through the lens of conscience. So without further ado, Alison, over to you.
Thank you very much, Kelvin. Thank you for coming, and thank you very much for the invitation to present to you today. What I want to be covering today is, in some senses, returning to something that is very familiar, the long-standing debate as to the proper analysis of a trustee's lien, the trustee's equitable interest in trust assets. That old chestnut that really is the gift that keeps on giving for equity scholars. Case after case seems to give rise to different aspects of it. The particular angle that I want to focus on is the rights of a former trustee who is removed and has an outstanding right of indemnity once the assets have been removed and placed in the hands of a successor trustee. And what scope there is in equity for a former trustee to seek personal remedies against a successor trustee in circumstances where a successor trustee dissipates those assets or transfers them to a third party who dissipates those assets. So I'm going to be looking at these issues through the lens of the case that was decided in the High Court of Australia. I'm sure many of you will be familiar with the case of Naaman and Jaken properties. That was a case where I want to start with the conclusion the court reached and then unpack that and work backwards. So the court found that the nature of the trustee's interest in trust assets is in the nature of a lien and not a beneficial interest held on trust. This had particular consequences for the claim by a former trustee, which through those proceedings had been premised or brought on the basis that if it is accepted that a former trustee's interest is held on trust by a successor trustee, then that would give rise to fiduciary obligations owed by the successor trustee and consequential scope for bringing a claim under one of the limbs of Barnes and Addy if there was any third-party involvement in a breach of trust. The High Court rejected that argument. And what I want to do is unpack not only the reasons for its rejection, but what questions it gives rise to in terms of what it means for our understanding of both the nature of the trustee's right of indemnity, the nature of the trustee's proprietary interest, and the scope for remedies for a former trustee who cannot claim to be owed fiduciary obligations. So I need to put this in the context, though, that these are now matters of, they are no longer matters of academic debate and curiosity under Australian law. The High Court has decided that the trustee's interest is properly characterised as a lien. There are many views and different views as to the nature of the trustee's interest, whether a trustee even has a proprietary interest in trust assets, that are no longer questions, open questions of debate. So one of the things that I want to do today is take the ratio of the majority in Jaken and understand whether some of the conceptual questions that have been floating around for decades can be resolved in a coherent way in an understanding of the trustee's personal and proprietary rights. When the decision was handed down after Naaman and Jaken was decided at the beginning of last year, there was widespread professional concern. Many practitioners assumed that a former trustee was now deprived of any really meaningful course of action to take against a successor trustee who dissipated assets. The concern was such that not only was there the concern on behalf of the former trustee, but that in fact it would lead to encouraging the phoenixing of trusts, winding up a trust, transferring assets to a successor trustee, and dissipating trusts in a way that was beyond the reach of the law. The premise of my paper today is that that is not a fear we need to have, and that there are principled reasons and mechanisms that already exist to allow a former trustee to have both personal remedies and proprietary remedies once the assets have, if the assets are dissipated, or rather, once the assets are transferred to a successor and if the assets are dissipated. So that's where I want to start. And before I start, I want to put it in the context of how important these questions are in the Australian context. So Australia is somewhat of the Galapagos Islands of commercial trusts, trading trusts. I checked last year's Australian Taxation Office statistics, and it noted that over 1 million trading trusts had lodged tax returns last year, 1.2 million companies. So we're now at a point where the trading trust is functioning as a de facto company. Once described as a commercial monstrosity by Professor Ford, it is now very much a part of our commercial landscape. So these issues are not just of enduring academic and theoretical interest, as they are to equity scholars. They have very, very real implications for the advice that practitioners are giving their clients. So what I want to do today is unpack these issues in the following way. I want to look at the nature, really, this is, in a sense, it looks like putting the cart before the horse, looking at the proprietary interest before the underlying right. But I want to start with what the High Court has decided in looking at the nature of the former trustee's interest as an equitable lien. How does a trustee have an equitable interest in property of which it is the legal owner? That is one of the conceptually challenging points or obstacles, theoretical obstacles, that has been raised for a long time against an analysis of a trustee as having an underlying equitable proprietary interest in assets of which it is the owner. And the way that I want to do that is by comparing the position of an absolute owner of property in which there are no equitable interests with the position of a trustee and the existence of equitable interests. And I then want to look at how that proprietary interest functions in the removal of a trustee. So look at the position where a trustee is a current or incumbent trustee, and then consider the position when the trustee is removed. I then will look at the nature of the trustee's underlying right to indemnification and whether it is possible to explain and understand the trustee's so-called right to an indemnity or entitlement to be indemnified in a Hofeldian analysis, which has often been regarded as the stumbling block for using a rights framework and the language of a right. In my view, it is possible to understand a trustee's right of indemnity in a manner that can be explained in a Hofeldian sense, both as an incumbent trustee, as a current trustee, but certainly once a trustee is removed and is in the position of seeking to enforce a right to be indemnified against a successor trustee. And then finally, I want to look at the remedial options for a trustee who finds themselves in the very unfortunate position, as was the case in the Naaman and Jaken case, of having had assets transferred to a successor trustee and then dissipated. How do can we, and if we can, on what basis is there a means to recover by way of either by way of personal remedy against a successor trustee or a subsequent third party without the avenue of a Barnes and Addy liability. So that's what the scope of what I want to cover. So I just want to put these issues and how they arose in the Naaman and Jaken case in a broader context. As we all know, the trustee's interest has the descriptions that have been given to the trustee's interest in trust assets has been for a very long time bedevilled by imprecision in the nature of the language. Courts have described it as a lien, as a beneficial interest, as a charge, as some sort of equitable interest that defies classical pigeonholes, and that uncertainty is in fact what led to the very issues in this case. So and I think it's noteworthy that in the Privy Council's decision in Equity Trust Jersey and Halabi, which was decided only 2 years before the Naaman and Jaken case, in that case the board preferred to avoid any characterisation of the proprietary interest of a trustee. The board said that it was simply a proprietary interest and nothing in fact turns on the precise language used. Well, as we'll see when we discuss this case, in fact, the Jaken litigation case shows that very important questions can turn on the language that is used and the way in which proprietary interests are characterised. So a little bit about the issues in the Naaman case, just to give it context for those who have not read the case. Naaman and Jaken properties concerned, and you can see by the dates that this is litigation that took over 20 years to resolve. It started back in 2005. It was a garden variety share sale agreement. Mr. Naaman was selling shares in his company to Jaken Property Group Proprietary Limited, trading as a trustee of the Sly Fox Family Trust. The director was Mr. Peter Slyman of the Sly Fox Family Trust. The share sale agreement involved payments. It was a $2 million sale, involved payments by instalments over 24 months. JPG made one payment under the share sale agreement, and it became very clear thereafter that they had no intention of paying anything further. Very soon after, in 2006, Mr. Naaman realised that there was a problem and sued in the Common Law Division for breach of contract. And this is where things started to unravel. Once proceedings were commenced by Mr. Naaman against JPG, JPG very quickly wound itself up in what was later found to be a sham transaction, a $2,500 debt from an accountant who happened to be the family friends of the directors. The trust assets were transferred to Jaken Properties Australia, with Mr. Slyman's brother as the director of the successor trustee. When the assets were moved to the successor trustee in the course of very protracted litigation, the successor trustee dissipated various assets to related third parties, to companies owned by the wife and sister-in-law of the directors. At all times, the properties were moved between related parties. And what happened was that eventually Mr. Naaman received a judgment for the amount owing under the share sale agreement. And at the same time, a declaration that the liabilities were properly incurred by the trustee. So it was within the scope of the powers as trustee to have entered into that agreement. At that point, the creditor registered various caveats over forms of property, and the litigation that actually ended up going to the High Court arose from proceedings brought not by the creditor, but in fact by the successor trustee seeking to have the caveats discharged to allow it to deal further with the property. In the course of those proceedings, Mr. Naaman brought a cross-claim seeking orders that the trustee had engaged in breaches of trust, and that the trustee held the assets on trust for the former trustee. So this was the first ventilation of the argument that a successor trustee holds assets on trust to the extent of the right of indemnity owed to the former trustee. In light of the movement of assets to third parties, it was argued that this constituted conduct that gave rise to Barnes and Addy liability. Now, the entire basis for this argument that the successor trustee owed the former trustee duties, fiduciary duties, was premised on the language of the courts describing a trustee's interest as a beneficial interest. In the New South Wales Court of Appeal, by majority, Justice Lemery, with whom Justice Kirk agreed, rejected this argument and said many people have equitable proprietary rights in the property of others, but that doesn't mean that every mortgage, every charge gives rise to a fiduciary obligation on the basis that the person who owes, the person who has the interest is in some way vulnerable to the actions of the property owner. Fiduciary obligations are not owed by the mortgagors, chargors, clients or purchasers to every person with equitable proprietary rights. Otherwise, every one of us here would owe the bank fiduciary obligations in respect of our mortgage. When it got to the High Court, the reasoning of the majority, I should say that Chief Justice Bell in the Court of Appeal accepted the argument that the language of a beneficial interest was one which indicated an interest held on trust. He would have accepted that argument. By majority in the High Court, the majority approved Justice Leeming's analysis and confirmed the nature of the interest as an equitable lien and not as an interest held on trust for a former trustee. The majority identified the features or characteristics of that proprietary interest in the same way as courts have for many years, has the features of the right to seek an order for a receiver to be appointed, to seek an order for sale, to seek injunctive relief, but never to receive the property beneficially. And critically, that it was not an interest held on trust. The minority, however, drew on these references to the interest as a beneficial interest in the trust, and were more, and you can see how the use of language to describe proprietary interests can give rise to these sorts of really critical questions as to what flows from that characterisation. Now, this case was decided 60 years after Livingstone's case, but it was back in Livingstone's case that Lord Radcliffe said that, in that now famous passage, that the terminology of our legal system has not produced sufficient variety of words to represent the various meanings that can be conveyed by interest and property. And in fact, in that case, which we all know was dealing with the interest of the interest in an unadministered estate, Lord Radcliffe said beneficiaries in an unadministered estate can be said to have an interest in the assets or even a beneficial interest, so long as it is understood in what sense that word interest is used. And this is precisely the same thing that was replicated in the Jaken case. And so, as I said in the introduction, when the Privy Council in Halabi said that that it's sufficient to describe it simply as a proprietary interest and that nothing turns on the precise language used, we can see quite how significant, in fact, the consequences can be when there isn't a very careful analysis of what the underlying interests are. So, with that introduction, what I want to do now is talk about the characterisation of the trustee's interest as an equitable lien, how we get there, and what that actually means. Now, at the outset, although this wasn't examined in detail in the High Court's reasons in Jaken, all of us here will be aware that there has been a very long-standing debate as to whether it is appropriate to say that a trustee has a proprietary interest in trust assets at all to secure its lien, to secure its right to indemnity. Here's an example, there are many others, where courts and scholars have said that it is simply anomalous to refer to a person having a charge or lien over property of which the person is the owner. Now, our High Court has said that that is the case, and one of my aims today is to explain, or is to say that there is in fact a coherent rationale for understanding the trustee's equitable proprietary interest in the assets to which it has title. Oops, going backwards. So where I want to start, slightly blurry image of a picture and probably one of your childhood books of the Little Prince. And the reason that I've chose that image is for the reason, as we all know, that the little prince lived on his little planet all alone. And the little prince owned that rose and took very good care of the rose. And remember, he put a glass dome over the rose. But what I want to illustrate with this picture is the fact that in the circumstances of the little prince and his rose, it is quite correct to say that it would make no sense to talk about the little prince having an equitable interest for himself over his own property. He owns everything on his planet. The 2 extinct volcanoes, the 1 active, the rose. The little prince is the absolute owner, and there is no one who has an interest in that title. This is not the way we understand the trustee's title to trust assets. The trustee, from the moment the trustee takes office, the trustee is holding those assets for the benefit of the beneficiaries. The trustee's title, it has engrafted onto it from the moment of the undertaking, the interests of beneficiaries. So in the context, when we're talking about how can it be that a trustee could have equitable interests in property to which it has title, we have to understand that we are not in the little prince category, we are in the category of people to whom the title over which there are already other equitable interests. Now, before we even look at the controversy in relation to whether a trustee can be recognised as having a lien over title, quietly in all of the textbooks, it is acknowledged in all of them that a trustee can have an equitable interest as a beneficiary in property to which it has title. What is the interest of a beneficiary? It is an equitable proprietary interest in title to the assets. So equity has long recognised already that a trustee can have another form of equitable interest for itself in the trust assets to which it has title. The recognition that the trustee can have an equitable interest by way of lien to secure its right to be indemnified is simply another form of equitable interest in title in the assets to which it has title. So the main challenge that I ask those who say that it makes no sense to say that a trustee can have an equitable interest in assets to which it has title is, how do you explain the trustee's interest as a beneficiary, if it is one, in a trust? Now remember, there are any number of statements to say that the little prince cannot be a beneficiary, cannot declare a trust and be a beneficiary. A trustee can never hold property solely on trust for themselves. But where held for others, it is accepted and it makes sense. So conceptually, that removes that obstacle to say that a trustee cannot have any form of equitable interest. Once I started going down this road, I realised there are in fact other equitable interests that are imposed on a party who has title and imposed for themselves, and a vendor's lien is another example. So a vendor still has legal title to property at the time that a vendor's lien is recognised. But remember that when that vendor's lien arises, there is already an equitable interest in another. So it's not a vendor holding property on trust for itself. The vendor's lien arises in the context that another equitable interest has already arisen. So when we look at the nature of the equitable lien that has been recognised, we can see that In fact, the features of the equitable interest that were accepted by the High Court identify the trustee's interest in absolutely classical terms as an equitable lien. Each of its features maps directly onto our garden variety equitable lien. The trustee can never take assets for itself in satisfaction of its entitlement. It can only seek an order for sale, the appointment of a receiver, injunctive relief, has no right to foreclosure, no right to title. These are the characteristics of the equities of the trustee's equitable lien that have been identified by the High Court for decades. And so one of the things that I think marks a distinction in the case law when we're comparing UK cases and Australian cases is a persistent reticence in UK courts and cases to accept the trustee's interest as a fully fledged lien, and rather a more cautious reference to it being some sort of sui generis proprietary interest. You see that all through Halabi, for example. Whereas the analysis that I'm trying to take us through with Jaken is to illustrate that, in fact, this is not some sort of challenge to the numerous clauses. This is not some sort of unique equitable interest. It is, in fact, a garden variety lien in all of its features. So the High Court took the opportunity to clarify one of its earlier statements, where in the Carter Holt Harvey case that many of you will know, the court had said that it is not a charge or lien comparable to a synalagmatic security interest over property of another. Many had seized on that language as supporting this idea that it's not really a lien, it's some sort of different type of proprietary interest. But the court took this opportunity to say, no, all we meant by saying that is to confirm that this is not a security interest that arises by agreement in respect of a pre-existing debt. And that much is clear. The trustee's entitlement to a lien does not arise from a pre-existing debt, but that does not deprive it of its characteristics as a lien. So, working backwards from understanding that there is in fact no conceptual reason to avoid or be hesitant to accept that the trustee can in fact have an equitable interest. What is that equitable interest securing? We know that every equitable lien is a form of security interest that must secure something. So what does it secure? So this is why we're working backwards to looking at the nature of the trustee's right of indemnity. Once again, we see a divergence between Australian law and UK law. In Halabi, the board said that the trustee's indemnity and proprietary interest were in fact one and the same thing. There's no difference between them. That is certainly not how Australian law has developed. And the Australian characterisation lends a more classical lens to the characterisation of the proprietary interest as a lien, because a lien secures some entitlement or obligation. Now, where a charge is securing a debt, that's a very common example, but it is not the only one. And in Carter Holt Harvey, Justice Gordon in particular, when she said a number of cases have adopted imprecise language, she was not there referring to the the board's reasons in Halabi, which had not yet been decided, but it is a point that is of relevance to how we think of the reasons in Halabi. Justice Gordon said, this imprecision generates confusion. The proprietary interest is generated by the right of exoneration or right of indemnity. That case only concerned a right of exoneration. The proprietary interest is not the right of exoneration itself. The right of indemnity generates the proprietary interest, which then exists to secure the entitlement. So I don't want to go over what in too much detail the history of what we already know, which is that the trustee's indemnity comprises the two limbs, as they're often known, the right to recoupment and the right to exoneration in respect of liabilities that are not yet paid. But one of the things that's important to understand is that the right of indemnity under Australian law is recognised as a chose in action. It is recognised as personal property that itself is assignable. And it is secured by this lien to ensure that the proprietary interest, to ensure that the trustee has a proprietary interest that will prevail in a competition with any of the other proprietary interests. So just going back, it's not that I'm not really picking on the Privy Council, it just sounds like it. But where the Privy Council says that there is no difference between the right of indemnity and the proprietary interest, they are one and the same thing, this is not the law in Australia. They are inherently related, of course, but they are not one and the same thing. So this brings us to the question, how do we analyse this entitlement to be indemnified? Is it appropriate to describe it as a right of indemnity, a right to be indemnified from the trust assets? Those who think of a rights analysis through a Hofeldian framework, can we analyse the trustee's right to be indemnified in a Hofeldian sense? Now, many have challenged that on the basis that the beneficiaries do not owe a duty to pay the trustee in the ordinary event. There are certain circumstances where they can. But the beneficiaries, in a broader sense and in a true Hofeldian sense, do owe a duty not to interfere with the trustee's exercise of their indemnity. So the right to be indemnified and the duty owed by those parties who have equitable interests in the properties not to stand in the way of the trustee's self-help remedy, the exercise of its power to take trust assets and use liquid funds to pay trust debts, is something that does lend itself to a Hofeldian analysis. Now, this is important because this allows us to see that the trustee's right to be indemnified, whilst they are a current trustee, even before they're removed, can be truly analysed as a right that is secured by an equitable lien in trust assets. Now, the power analysis of the trustee's indemnity has a very strong and long following amongst equity scholars and courts. And it's important to note that the High Court has addressed the power analysis of the right of indemnity. And in Carter Holt Harvey acknowledged that whilst it may be accepted that a trustee has a power to apply trust assets in discharge of its properly incurred liabilities, the power analysis and the rights analysis can exist together. It's not inconsistent. They're not mutually exclusive. So it is in an exercise of its right that a trustee has a power to apply liquid trust assets to the discharge of liabilities. And in that way, the two analyses are not set up in competition, but rather support each other. Now, on removal, once the trust assets are removed and now a successor trustee has title to the assets, this gives much more clearly an analysis of a security interest in property owned by another and a right that is exercisable against another. 5 minutes. This brings us now to I guess where I want to take this analysis, because if we accept these building blocks, these foundational steps in the analysis of the trustee's right and security interest, what are the consequences? Well, the consequences are that if a successor trustee owes a duty to pay a former trustee the amount of its entitlement, and if that personal obligation is secured by a proprietary interest by way of a lien over those trust assets, the next question that flows from that is where a successor trustee acts in disregard or in breach of that duty, and where a successor trustee dissipates assets that are the subject of that lien, what will a court of equity do? Will a court of equity say, shame? Or will a court of equity actually enforce the underlying entitlement and provide a personal remedy for a successor trustee who knowingly dissipates assets that are subject to the lien? Now, this has never been tested in the context of a former trustee and a successor trustee, but it has over 2 centuries of case law in the context of a solicitor with an entitlement to be paid for their costs, enforcing a lien against a party who owes no debt to the solicitor, but is in possession of funds over which a lien exists. And in these cases, and I go through them in the paper that I'm developing and which I'm happy to share, these cases say that the knowing dissipation of assets over which an equitable lien exists is the personal wrong of the party who had those assets, and is one where a court of equity will enforce, or rather will grant a remedy requiring the party to pay that amount personally. Now, when you think of it in the context, and not only that, going back to the 18th century, we have cases where the courts have said that this applies not only against a person who has the property over which the lien exists, but third parties who also take with notice of the right. Now, where does this take us? It takes us through to more recent cases of the Supreme Court, explaining the normative reasons for granting a personal remedy against somebody who breaches or who acts in disregard of the lien over the property. That it is, and the normative explanations are that it is against conscience to know that you are holding property to which someone has an entitlement and then to knowingly pay it away and deprive the party of that. So that a person who owes no debt whatsoever to a solicitor can be made to pay that amount personally simply by having acted in disregard of the interest. So where does that leave us? I think that leaves us with a very principled basis for regarding the trustee's lien as something that is equally enforceable. And where a successor trustee were to act as egregiously as the trustee did in this case, where at all stages the successor and third parties were found to have knowingly dissipated assets with the precise intention of depriving the trust creditor of his assets, that it provides a very clear pathway to personal liability against a successor or a third party that is consistent with principled administration and supervision of trusts by the courts. Chapman and Chapman, it is the function of the court to execute a trust, to see that trustees do their duty, protect them if they do it, direct them if they are in doubt, and if they do wrong, to penalise them. Not sure about penal nature of equitable remedies here, but I don't think now's the time to take that. But the point is that these are certainly within the scope of the court's administration of justice, or these are issues that a court will have jurisdiction to address. So this is where I want to finish. So yes, there is a need for clarity as to the nature of the trustee's right of indemnity and supporting equitable proprietary interest. I think we have that now under Australian law. And I think it will be interesting to see how the reception of Australian law is in this is treated in other jurisdictions. It is clear under Australian law that these rights are separate. They are not one conglomerate indemnity proprietary interest, and there are clear and principled ways of explaining the nature of these separate interests and the way they work together and how they are to be enforced.
Please join me in thanking Alison again.